County, Kansas, case entitled State of Kansas versus Jordan J.D. Dillon, case number 2023 CR 82. James Watts appears as defense counsel, Amber Norris on behalf of the state of Kansas. Jordan Dillon appears from a court security Zoom location at the Butler County Judicial Center. Before the court is a warrant to show cause alleging probation violation, including failing to obtain full-time employment as directed, positive urine samples, failed to re-engage in substance abuse treatment as directed by his ISO. Mr. Watts, what are your client's intentions regarding these allegations?
Thank you, Your Honor. As to the first allegation that failed to obtain full-time employment, my client would acknowledge at the time of his arrest on this warrant to show cause, or at least at the time of the issuance of the warrant to show cause, he did not have full-time employment. I will note for the record, my client tells me he is now working at Spangles, in fact, has work tomorrow. So that has changed. As to the second allegation, submitted positive urine samples on a number of dates, he would agree with that and stipulate to that violation. And as to number three, failed to re-engage in substance abuse treatment, he would acknowledge that at the time of the issuance of the warrant, that was correct. He would stipulate to that violation, would tell the court he is now, and it's my understanding Mr. Ketley is aware of as well, is now back in a treatment program.
All right. All right, Mr. Dillon, you do have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence, present your own evidence, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, Your Honor.
Do you waive a hearing and stipulate and agree that you committed the violations as qualified by your attorney, no doubt, as to 1, 2, and 3 of the warrant to show cause?
Yes, Your Honor.
All right. Court finds that the defendant has waived a formal hearing on the allegations, stipulates and agrees that he committed the violations as alleged. Mr. Ketley, can you confirm that the defendant has re-engaged in a substance abuse treatment program at this point?
Yes, Your Honor. On 3/11, he met with Higher Ground and they went back over his evaluation and reinstated him into treatment.
Very well. Has he provided any verification of being employed?
No, but when I met with him when he was taken into custody, he mentioned he was working at Sonic, and I even spoke with his grandma, and his grandma had admitted it or stated that he was working at Spangles also in Andover.
Okay. All right. Do you have recommendations at this time, Mr. Ketley?
Well, Your Honor, we've had, I was kind of hoping it wouldn't have got to this point. We've already had 2 sanctions for roughly the same type of stuff, using marijuana. And Central County said that until we have a little bit harsher sanction, then they sent him back, but they will take him back if it gets to that point.
All right. What are the state's recommendations here, Ms. Norris?
Our state will be recommending 30 days in the county jail. This is defendant's second warrant to show cause. And in the interim, since the previous show cause, which was in June, the defendant has had both a 2-day dip and a 3-day dip that he agreed to voluntarily with his ISO, both of which had to do with him not getting back into treatment. So that has been a consistent problem since the last warrant to show cause. So we would ask 30 days in the county jail, that he complete get into and complete drug and alcohol treatment. And Your Honor, he would need a 12-month extension. I believe at his last show cause in June, he was extended 12 months on June 21st, but to avoid him not being able to complete treatment within the allotted time, state would ask for a 12-month extension from today's date. And the court will need to address court-appointed attorney's fees as Mr. Watts has been reappointed.
Mr. Watts, your recommendations regarding an appropriate disposition.
Well, Your Honor, I will note, as I mentioned earlier, Mr. Dillon didn't hesitate to acknowledge where he'd failed here. He didn't try to deny any urine samples. There are a couple of things that has changed. A, he has work. In fact, I understand he has work tomorrow at, you said $17, $18 an hour? Is that correct?
It's $12 an hour.
$12 an hour. Okay. So he has work tomorrow, and he's desperately wants to go back to that. There's one other thing that's changed. Mr. Dillon tells me he has a child born sometime last month. I don't know the exact date, born in February. And perhaps most important, first thing I asked him when we came on is, if you tested today, would he be clean? And the answer was yes. He was in jail from February 14, according to Mr. Dillon, arrested on the 14th, out March 3rd. So he's had about 17 days in custody. Since March 3rd, we're now at the 14th, not quite 2 weeks. He tells me he is clean. Again, I've not tested him. I have no way to do that. But if that's the case, we're making progress. He has work. He has, at this point, back into treatment program, and he has a child now to take care of. And he spent 17 days in county jail. So, Judge, what I'd like to say is that the time that he served should take care of that sanction and should get his attention. 17 days rather than a 2 or 3 day dip. If the court believes it is necessary to impose further sanction, I would encourage the court to schedule that time so he can continue to attend his job and continue to work.
How much are your fees in the representation of the client on this round of proceedings?
Judge, we're billed for $880 at a show cause.
All right. Mr. Dillon, I'll address you personally and I'll ask you, do you have any statements that you wish to make in mitigation of punishment here, or anything further that you would like to present to the court?
No, Your Honor.
You just had a child born to this world?
Yes, he was born February 25th. And
His
his
name?
mom's in the hospital right now. So with
What's the child's
schizophrenic.
name?
Leonidas.
And I trust he has a last name?
Yeah.
Dillon?
Oh, last name? Yeah, Dylan. Yeah.
Oh, okay. It
I'm
wasn't
sorry.
a good question.
Sorry.
All right. And you're saying the mother is in the hospital right now? So who's providing care as we speak?
Me and her grandpa. Or his grandpa, excuse me. He's a little guy. He was born a month early.
He's off to a rough start, obviously.
Yeah, well, his mom, she's not the best, so.
Well, Mr. Dillon, why are you taking chances when you've got a child to take care of? I don't understand why you're just not doing what you're supposed to be doing. You can stay in the community. You can be on probation. You can take care of your child. If you do what you're supposed to do, you don't have to serve time in jail. But unfortunately, your track record is you just can't consistently do what you're supposed to do.
Well, me serving that time has really woke me up. I'm going to be honest with you. That and not being there for him when he was born, that really hurt me. I understand that I have messed up and I am making an effort to make it right. I promise you that. And all my fines are paid off. Well, of course, I'm going to have more, but from previous, everything's been paid off.
You like marijuana?
No. I did, but not now. I've learned my lesson. I do not want to go to jail. I've learned my lesson. Trust me. I like I told him I would be clean today if I do a UA. I have not used. Like I said, I'm back in treatment. I'm making an effort for my son and for me.
You have a lot to be on probation for, Mr. Dillon. You're just about ready to blow it.
I know that, Your Honor.
All right, first of all, the court's going to take into account that Mr. Dillon has served 17 days in jail in regards to this warrant to show cause. The court, while believing at least on its face that the state's recommendation is sound, the court's not going to order the 30 days of sanction time, which was suggested in this case, rather recognizing that Mr. Dillon has taken some corrective steps regarding the allegations which are currently before the court. The court at this time will take into account the 17 days previously served, but there must be a prospective sanction here. Mr. Dillon, in some ways, I'd really like to make this hurt so that you sit in jail and you wonder what in life you're giving up. And I'm not necessarily wanting to interfere with a job that you've just started, but I'm going to order you into custody immediately to serve an additional 48 hours in jail, starting immediately. While a court could make that a much, much longer sanction, and perhaps under these circumstances it should, again, taking into account that it's already cost you 17 days of your life on this round, and the deprivation from your young child who probably needs you right now, but apparently, at least at one point here, relatively recently, marijuana was more important to you than any of that.
Yeah,
You need to break yourself from that, Mr. Dillon.
I have, Your Honor.
Your son's counting on you to do that.
I have. I promise you that.
All right. Mr. Ketley, at the first in-person meeting after he is reinstated onto your probation, in other words, as soon as he gets out of this 48-hour sanction period, he's reinstated on community corrections and extended through December 31 of 2025. He needs to satisfy any condition that hasn't been previously satisfied, including a proper re-engagement and completion of a substance abuse treatment program and any aftercare recommendations. But at that very first meeting, Mr. Ketley, I'm going to order that he be UA'd. I know you're probably just as interested as the court is. Is he telling the court the truth that he's going to be clean on a UA right now? I wonder. I hope so. Dylan, I have every reason to believe you, but we're going to check that out.
I just did a UA for my treatment, so.
Well, I'm going to want Mr. Ketley to do another one.
Okay.
You and marijuana are permanently divorced, Mr. Dillon.
I know that, Your Honor. Trust me.
Okay. All right, so I've extended probation through the end of this year. Ms. Norris, I need to address further assessments in the case. Because you messed up again, Mr. Dillon, I really should hit you with some additional bids costs in this case. I'd rather see you spend this money on your son and his care.
I appreciate that, Your Honor.
He needs to be the recipient of the funds that you earn to some extent. So I'm not going to assess any additional bids amounts at this point. I'm ordering Mr. Dillon into custody to serve 48-hour sanction time effective immediately. With that re-pronouncement, Ms. Norris, is there anything else we need to address?
Your Honor, what was the day in December of 2025 for completion?
I am extending him through December 31 of 2025.
31. Okay. Thank you, Your Honor. Nothing further, I don't think.
All right. Mr. Ketley, do you have any questions or any further clarification needed?
No, just Dylan, I need to call me first thing Monday morning and let me know when you can come in.
Yes, sir.
And when you get to jail, call your job too.
Okay.
All right, Mr. Watts, anything further that the court needs to address currently?
No, sir, thank you.
Very well. Then the Jordan Dillon matter will currently be in recess.